Hi, I'm Jacob Stein, and I'm an asset protection attorney. I am a partner at Aliant's Los Angeles office, and I've been practicing asset protection planning for about 25 years. We represent clients around the world and help them protect assets from claims of creditors, plaintiffs, government agencies. And in this brief video, I would like to give you 3 reasons why you should never use a Cook Islands trust. And I know that sounds unusual because if you listen to a lot of other attorneys out there, a lot of asset protection salespeople, service providers, a lot of them are marketing Cook Islands trust. And just super brief history, I used to set up a lot of Cook Islands trusts. If you go back 20 years ago, we were setting up dozens and dozens and dozens of offshore asset protection trusts in the Cook Islands. The Cook Islands was the OG offshore asset protection jurisdiction. Great trust law, great asset protection law, lots of protections that they have developed with the help of American asset protection attorneys to attract the asset protection business from the United States. And 20 years ago, the Cook Islands was great for asset protection. Again, fantastic laws to protect assets of trusts that are domiciled in the Cook Islands. We stopped using the Cook Islands about 15 years ago. And here are 3 quick reasons why I do not believe anyone should use the Cook Islands for offshore asset protection planning, maybe with some super narrow exceptions. So reason number 1, the Cook Islands became just too successful for its own good, meaning that they're infamous as an asset protection jurisdiction. This is what the Cook Islands are primarily associated with nowadays, right? So if someone tells me that they have a Cook Islands trust, I know without any doubt that they set up that trust for asset protection planning. And that means that your plaintiff, your creditor, your judge will also immediately assume that the reason you have a Cook Islands trust is because you are looking to protect your assets. Whereas if you set up a trust in some other offshore jurisdiction, and there are now a number of jurisdictions that have laws that are at least as good as the Cook Islands, and I think some of them are better now than the Cook Islands. These jurisdictions are not as infamous as the Cook Islands. So we want to be able to argue that there is some other reason for this offshore trust, right? Something other than asset protection, we can do so. But we cannot with the Cook Islands. Reason number 2, because of the success of the Cook Islands as an asset protection jurisdiction, thousands of offshore trusts were set up and domiciled in the Cook Islands. And a lot of the litigation involving offshore trusts relate to the trust set up in the Cook Islands, which also means that anytime you have negative case law, negative as to debtors, case law that says that a debtor can be held in contempt of court or a creditor should be able to reach the assets of an offshore trust, which doesn't happen often, but there's case law like that. A lot of that case law deals with trusts in the Cook Islands, right? And I would much rather set up my client's trust in a jurisdiction other than the Cook Islands where there is no negative case law. Reason number 3, in litigation, one of the bigger sticks you can wield is uncertainty, right? You want the other side, your plaintiff, your creditor, to have uncertainty as to their ability to collect, as to their ability to reach the assets in your trust, in your offshore trust. And with the Cook Islands, it's a known factor, right? It's not easy to reach the assets in the Cook Islands trust, but because the Cooks have been around for such a long time as an asset protection player, because there is so much case law that has been developed, there's a lot less uncertainty than some jurisdiction that no one has ever heard of before, that where there is no case law. So for the past 15 years, just as an example, we've been using St. Vincent and the Grenadines a lot for our offshore trust. We've been using Nevis a lot. We set up trusts sometimes in Europe in different countries because there is no case law in these jurisdictions that is adverse to debtors, right? These jurisdictions are not automatically associated with asset protection planning, and there is a lot of uncertainty that is created for plaintiffs and creditors in using these jurisdictions. So there you go, 3 reasons why you should not be using a Cook Islands trust to protect your assets overseas. Thank you. I'm Jacob Stein. See you next time.